All right, please be seated. All right, we will take up next the case of State of Florida versus the Bradenton Group. Is there any time you'd like for rebuttal?
5 minutes, Your Honor. My name is Louis Hubener, representing the appellant, the State of Florida Office of the Attorney General. This case has a substantial amount of history, but I'm only going to allude to so much of it as is necessary for my argument. In this court's last opinion in 2000, which I'll refer to as Bradenton 3, the court held that the RICO action brought by the state under Chapter 895 was barred by collateral estoppel, that bingo violations were not punishable under the RICO Act, and that the trial court should consider defendants' entitlement to damages. There are 3 reasons why they are not entitled to damages. 2 are legal and jurisdictional.
As I read the opinion, it says the defendants argue that they are entitled to damages for the state's wrongful injunction entered in 95. The state responds that they are not entitled to damages because no bond was entered, the injunction was not wrongful, and it is illegal to profit from bingo. The defendants are correct. And that sounds like the prior panel decided that the defendants were entitled to damages, and there's additional language that suggests that as well.
Well, that's in part C of the opinion, but those are threshold issues that do not get to any of the defenses that the state had previously asserted in the case, which included...
Well, isn't the general rule, AIRVAC and other cases, that if you lose an argument or issue below and don't bring it to the appellate court's attention, that you waive that issue?
We didn't lose that argument below, Your Honor, in the 2005 trial. If I may direct you...
At volume 17, page 2930 to 39, you filed a motion to dismiss the counterclaim arguing sovereign immunity and prosecutorial immunity. That was denied by order dated November 4th, 2003. In volume 19, that whole volume is your motion for summary judgment, which raised those same issues, and that was denied in volume 22, page 3880. So those issues were clearly and definitively decided against you at the trial court level, and you didn't assign the matter as a matter for cross appeal. You didn't argue those issues as a basis to uphold the trial judge's ruling as tipsy coachman. So I'm having a hard time understanding why that was not waived.
If I may take you, well, in the first place, they are jurisdictional and cannot be waived. But what the trial court did at the end of the 2005 trial, in its consolidated order, it found that the fact that the jury had found that the defendants had engaged in racketeering activity precluded any claim for damages. So that was not even an issue at that point in terms of the defenses. The court didn't even get to our side of the case in 2005. There was no ruling against us on the damages on the damages issue at that time.
The denial of summary judgment, the denial of motion to dismiss are not rulings against you?
Those are not merits. Those are not.
You can't assign as error in cross appeal the denial of a motion for summary judgment and a denial of motion to dismiss?
You can, but when the court entered this order in 2005, it said that they had no claim for wrongful damages. So therefore, it wasn't an issue for
but
us.
you lost on that issue. You lost on that issue.
Well, I would respectfully disagree that we lost on that issue.
On appeal.
When the court said that they had no claim because of the racketeering finding of the jury. If I may refresh your memory, at the end of the 2005 trial, the jury returned a verdict against the defendants, finding that they had engaged in racketeering activity. The court then held a brief proceeding on the damages claim and refused to rule on it, said that they didn't have a claim because of the racketeering finding of the jury. So on appeal, sovereign immunity and prosecutorial immunity were not raised. When the case went back after the 2007 opinion, they filed another motion for wrongful injunction damages, to which we again responded, asserting prosecutorial and sovereign immunity. The court, without any explanation, simply denied that. But I would say that the case law is clear, and the Wallace versus Dean decision, which is cited in the brief, and I filed as supplemental authority, that governmental immunity goes to the subject matter jurisdiction of the court and cannot be waived. So we would say that those arguments are still viable and are still before the court.
You don't deal with these cases, even though they're cited by the other side, but Dunham versus Brevard County, sovereign immunity and subject matter jurisdiction were specifically argued at the trial court in the prior motion to dismiss, and they were therefore settled adversely to appellee by the prior appeal because they were waived. And then there's there were several cases that were cited. The other is Williams versus City of Mineola, which suggests that sovereign immunity can be waived.
Well, the Florida Supreme Court's latest pronunciation on that is stated in Wallace versus Dean, which we cited at 3 Southern 3rd, 1045, note 14, and it says that they go to the subject matter of the subject matter jurisdiction and cannot be waived. So I would rest on that, and I'd like to proceed with the argument on that. I'll be brief and then move on, because there are other issues, I think, that require reversal of the judgment. The argument on immunity is simply that there can be no implied waiver. Nothing in Chapter 895.05 purports to waive the immunity of the Attorney General, nor does any provision of Chapter 60. The defendants rely completely on the two Provident management decisions, which address the sovereign immunity of municipal corporations.
Let me ask you this. Back in 1995, the Attorney General had a choice of whether to seek a temporary injunction or not. They could have filed their complaint, sought a permanent injunction, not bothered to go through a temporary injunction, had the issues fully presented to the trial court, get a ruling either to grant or deny the request for injunction. And in that scenario, it seems to me that under the Provident case, that the Supreme Court would say, you have sovereign immunity. Would you agree with that?
I think we have not only sovereign immunity, prosecutorial immunity.
All right.
Yes.
But in the Provident case, didn't the Supreme Court say, but if you decide to go out and get an ex parte temporary injunction and pass on the option of waiting for a full resolution of the issue, then you're like any other civil litigant. You lose your sovereign immunity. I mean, isn't that what the second Provident case says?
That's what it said with respect to municipal corporations.
Right, but in that case, they were interpreting the limitation of damages, and I don't see any language in there which suggests that they were limiting it to municipalities. Would you agree with that? I mean, didn't they refer to governmental entities throughout the opinion?
Well, they refer to governmental entities because governmental entities are mentioned in the Rule of Civil Procedure 1.610. But a rule of civil procedure cannot waive prosecutorial or sovereign immunity. Only the legislature can do that, and it has not done it for the Attorney General or the state attorneys who are authorized to bring actions under Chapter 895.
The Provident decision, Provident management, discusses the fact that the County Attorneys Association and other entities filed amicus briefs in that case because they were concerned about the broad implications if this applied to all governmental entities. It seems to me like if the Supreme Court wanted to narrow its ruling to cities, it would have said that.
Well, only a city was a party. There was no. I think there's a difference.
Courts know how to do that in a footnote. This only applies to cities. We haven't addressed the broader issue of whether this affects other governmental immunities. I mean, that happens all the time, particularly when there are entities there, governmental entities. The state is there arguing that you shouldn't apply this rule because it will have broad implications. I mean, I just cannot see reading that case as narrowly as you're talking about, given the language, broad language.
Well, for one thing, the immunity of a municipality is vastly different from the immunity of the state or the immunity of a prosecuting officer. The Attorney General is not enforcing a zoning code like the city was doing in the Provident Management case. Chapter 895 enforces criminal law. It gives the Attorney General the authority to seek an injunction which would enable the state to stop a criminal enterprise in its tracks. Now, if you say that the Attorney General cannot do that without incurring liability, you are saying that, in effect, that the authority is meaningless. And I think the legislature came along and corrected that impression when it enacted Section 60.08 after the Provident Management decision came down, and said that an injunction, this is in 60.08, an injunction under Chapter 895.05, parenthesis 5, and a couple of other statutes, shall issue without bond. Now, the legislature was not putting the Attorney General in the position of having unlimited liability when it said that an injunction shall issue without bond under that statute. And I think that is the way the statute, the Chapter 895 should be interpreted originally at the time this case began.
You'd agree the Supreme Court made no effort to distinguish between municipalities and state agencies in that Provident case?
No, but it did in another case we cited in the brief, the American Home Insurance case, where the city of Kissimmee was held liable under a contractual arrangement whereby it had agreed to indemnify.
That wasn't a sword and shield doctrine case, was it?
No, that was
we all know the difference between a city's sovereign immunity.
But the state attorneys and the Attorney General are nothing if not sword wielders when they come into court under 895. They are trying to stop criminal activity. And if you say that they have no immunity when they're doing that, then I think you render that chapter, you just cut the heart out of it, for one thing, and that conclusion is inconsistent with the amendment to Chapter 60 in 60.08.
Didn't the state have the choice of proceeding with a criminal RICO action as opposed to a civil RICO action? Certainly your argument would be stronger then.
Well, it did proceed with criminal actions against those that it believed were violating the bingo laws. It didn't
pursuant to the civil laws.
No, there were some criminal prosecutions, and as a matter of fact, 3 of the principals of New Way and Ogden, who were the corporations that bought the bingo business from the defendant corporations here, pleaded guilty to criminal charges.
And others were convicted, and those convictions were overturned. Is that correct?
I think there was some that were overturned, yes.
Should we give any weight to this? In that Provident case, the certified question from the second referred to municipalities. It said, do the limitations on liability in Section 768.28 apply to a claim for wrongful injunction against a city that was not required to post an injunction bond? The Supreme Court changed that and said the issue presented by the certified question in this case is whether the limitations of liability contained in Section 768.28, the statute waiving the state's sovereign immunity for tort claims, applied to limit an award of damages caused by a wrongfully entered injunction obtained by a governmental entity. It seems to me that the Supreme Court got a limited question from the second on municipalities and intentionally chose, expanded that to reframe the issue to make it broader. Am I reading that wrong?
What they found in that case, though, was that a wrongful injunction was not a tort.
And how would that differ from this case?
Well, the way it differs is that in this case, we have prosecuting officers who are not municipal officials, and their immunity is different. Prosecutorial immunity derives from Article 5, judicial immunity.
You think what would be the argument why prosecutorial immunity is not waived here when you're under the sword shield doctrine? Why should it be different
Because
applied to prosecutorial immunity than the Supreme Court applied it as to sovereign immunity?
Because the legislature didn't waive it, and a waiver of immunity must be clear and explicit. And there is nothing in Chapter 895 that even purports to waive.
But you could say that about the result of the Provident decision as well.
No, because the immunity of municipal officials is different.
Well, assume that we do not agree with, assume that I can't speak for the others, I read it that case more broadly. I think I'm bound by Provident, whether I like it or not, and I think it says it applies to governmental entities. That's what the Supreme Court said. So that's not true about Provident as I understand it, as I've just articulated it to you, correct? I mean, there's no waiver of sovereign immunity by the legislature that the Supreme Court relied upon to reach that decision.
Well, I think the problem is that municipal officials don't have immunity unless the legislature confers it on them. So they didn't have it to start with. And the city even conceded in that case, right up front, that it didn't have immunity from a damages action.
You're a little over 4 minutes.
I know there's 2 points I would like to make quickly that I think are also dispositive of the claim. And one is that a wrongful injunction and damages are awarded as a matter of equity. And here the trial court tried to blame the Attorney General for not taking any action to mitigate the defendant's damages. Well, one reason for that was that defendants were hiding out in Canada because they had been indicted a week before this RICO action was brought, and they did not, Mr. Padgett did not come back to Florida until the year 2000. Mr. Fertney was apprehended in Montana in the summer of 1966. During that critical 7-month period, no one was available. They did nothing to mitigate their damages. And this court held in Jaffe versus Snow that when you deliberately absent yourself from in certain circumstances like that you forfeit the claim.
Didn't the trial judge find that nothing really would have made any difference in terms of mitigation of damages?
No, that's not what he found. He said he didn't know what would have made a difference.
He said it would be sheer speculation or something like that?
Well, I don't think it is speculative.
I have a hard time seeing how someone can mitigate their damages when you seize all their property, all their bank accounts, arrest all their employees, take everything, and enjoin them from doing anything.
The trial judge said he was willing to modify the injunction. There was no motion for a receiver to be appointed until 10 weeks after the injunction was issued. That receiver promptly violated the court's order and was removed. If they had acted in a timely fashion, they had the right to file a motion for a receiver or some other modification, have a hearing within 5 days of the filing of the motion. They did nothing.
Well, let me ask you this. If these various individuals had just been charged with a crime and the Attorney General's office had only sought a permanent injunction, as a practical matter, you would have gotten all the results you did, not be facing any potential liability here. Is that correct?
Would you repeat that question, please?
Well, if these various individuals were charged with a crime and the Attorney General's office sought a permanent injunction without seeking the extraordinary relief of a temporary injunction, as a practical matter, you probably would have shut down those operations and you wouldn't be facing any claim for damages now, would you?
I don't know. I don't think I could necessarily agree with that.
But instead, the Attorney General sought the extraordinary relief to get a judge's stamp to go in and seize all these matters before there was a full opportunity to be heard, or even with notice to the other side, correct?
That's true, and they had the obligation to come right back in.
And wasn't that the concern that the Supreme Court had?
Mitigate their damages.
That was given too much power, and to balance that out, that if you did that, there'd be a waiver of immunity? I mean, isn't that what the Supreme Court really based its decision in Provident on?
In Provident, yes, but then subsequent to that, or almost simultaneously with the Provident decision, you had the legislature enacting 60.08 that said an injunction an injunction shall issue without bond. I have 1 minute left. I'd like to save that for rebuttal. Thank you.
I'll go ahead and give you 2 extra minutes for rebuttal.
Thank you.
Good morning. Steve Mason for the 3 corporations. I want to just talk about what happened in 2007, and I don't mean any disrespect to Mr. Huebner because he is an absolute gentleman throughout these proceedings, but When you entered your opinion in 2007, the Attorney General's office in the state of Florida clearly and unequivocally understood that the question of damages, the subject of damages, our right to damages had been decided. And they were extremely upset about that, and we know that for two principal reasons. And one of those reasons is they filed a paper with you after the opinion, a post-opinion paper, and in there they say in the first paragraph, we're not going to re-argue the merits of this appeal, but what we want to talk to you about is we're subject to damages, and these are my words, and they go on page 3 and they articulate the damages that we were seeking, $2,148,000, $4,740,000 plus interest, etc., and they refer to exhibits, and then they ask you pointedly, clarify and tell them they're not entitled to these specific profit damages. And you denied that motion. From there, they filed a paper, an appeal, a discretionary review with the Florida Supreme Court in what I would describe as an extremely emotionally charged jurisdictional brief where they scream a couple things, where the words jump out of the paper, that they're subject to $10 million worth of damages, and if we don't get relief from you in Tallahassee, we could have to close up shop. Now, Mr. Huebner can come up here and correct me if I'm wrong on that, but if they honestly, truly, I understand lawyers are advocates, but if they really, truly disbelieve what happened in 2007, what the import of that opinion was in 2007 authored by Judge Thompson, then they would not have filed those papers. What happened is...
How do you address the argument that Wallace versus Dean says that sovereign immunity can't be waived and can be raised at any time?
Wallace versus Dean doesn't even remotely say that. In fact, Wallace versus Dean is a 25-page opinion about something called the Undertaker's Doctrine in the parallel to 768-28. And after you slog through that 25-page...
I had a hard time with that, too.
After you go through this opinion, you're blurry-eyed after you read this 25-page opinion. What we have to focus upon is a footnote. And the footnote says something to the effect, sovereign immunity can't be waived, and it parallels to what they're talking about in the opinion. And me, the retentive lawyer that I am, I go back and I pull the cases cited in the footnote. And I actually have them in my briefcase, and I highlighted them in yellow. Both the cases that are cited in the footnote say just the opposite, that sovereign immunity can be waived. And they use the words, unless sovereign immunity is waived or someone does something through estoppel, then you have this immunity under 768-28. But I'm telling you, both the cases that are cited in that footnote have affirmative language that are factually specific that completely contradict what they're saying in the footnote. And if common sense has a role in the process, if they were right on this, and you could never waive anything, you could never waive it, and their argument is that unless you articulate and address their arguments specifically, and more importantly, to their satisfaction, they can come back. Because, we've had lots of discussions, and I'm not throwing stones at him, but irrespective, let's just assume hypothetically the court rules in our favor. This case, do we honestly think this case is going to end? They're going to go back and they're going to say, you know what, you can't force us to do anything. We're not going to give you a nickel.
Assuming that sovereign immunity can be raised for the first time during these proceedings, how do you respond to the claim that they're immune from having to pay?
Well, for instance, the one thing that strikes me factually about this, and I went back and I thought about it some more yesterday, 1996, Provident Management starts percolating at the second DCA opinion. First opinion was written by Judge Alterbin, and it kept bouncing back and forth like cases do to Tallahassee. Well, our case was bouncing around at the exact same time. We were in front of you in 96, 97. We were in front of the Florida Supreme Court in 98, 99. We filed a paper in front of the Florida Supreme Court asking for fees under the wrongful injunction statute 6007, and they affirmatively, unequivocally granted, citing 6007. What I think is going on is the same thing that happens with judges in every court. These judges had been thinking about this issue. They knew that it applied. I think they knew it was coming down the pipe in Provident Management, because we know that because Justice Wells jumped right out and said, sword and shield doctrine, I'm citing all these cases from around the country, and he wanted to jump on that thing bright and early. They granted that under 6007. And they don't, those 7 justices up there don't willy-nilly grant things under a wrongful injunction statute if we weren't entitled to under damages under 6007. So I think that's significant, and that's obviously significant because you discussed it at some length in your 19 strike that, your 2007 opinion. Aside from that, there's nothing in Provident Management to suggest that they're right, and more importantly, they relied on, I call it the Kissimmee case. It's the insurance case about the train that went off the track, and there was a complicated contractual dispute about an indemnification clause. They grab onto that, and they cite the concurrence of Justice Cantero. Well, Justice Cantero reviewed this case in 2007, 2008 when they petitioned for a review, and they wrote a brief that you may read 10,000 briefs in your professional lifetime. You read this brief, you'll remember it when it talks about we're going to be shut down or words to that effect if you don't give us aid. Justice Cantero, it was a 5-0 denial of review. They didn't get one single vote to even review and reverse this court. This case should have been decided, and they should have fought this case on damages. They should have fought it on the specifics of damages. They should have attempted from a business professional standpoint to mediate, but instead they won't even talk about a resolution. They won't talk about a mediation. They foreclose every opportunity at mediating and talking about this case, whether it be Judge Palmer at this court, Judge Johnston. The first conversation we had with him, he says, why don't you get together and mediate? And they just said, no, we're not going to mediate this case. So it isn't as if the last 15 years we haven't been trying to work it out with them. And you know what the irony of this is? And if I'm getting off or digressing, I apologize. But the irony is that this case would have been resolved at such a smaller number. Right now...
Yeah, don't talk about settlement talks. Just focus on the issues.
Those are the three significant things that strike me about the issue of sovereign immunity. In terms of this issue of what we could or could not do, I think it would be an exercise in futility to think, how could have we changed what was occurring? I mean, in this case, every time they tried to sell a piece of property, they tried to sell Avon Plaza, the Attorney General writes a very strongly worded letter. It scares people. They can't sell it. They try to close on the, and I don't know if this was by design, but they were trying to close on a piece of property in Ocala. They couldn't do it. The injunctions entered approximately 2 or 3 weeks before their closing date, and all their assets are frozen. They bring in an accountant, a CPA, to reopen the bingo halls. He does exactly that, brings in a completely different operator, a different charity to earn money to save that property from foreclosure. And they just, I mean, it was the power of beyond power that they came in and held him in contempt. And if
Let me go back to the immunity issue. Do you believe the scope of prosecutorial immunity is broader than the scope of sovereign immunity?
I've read their prosecutorial immunity argument many times over, and I still do not understand that argument. And so I go back and I read the cases that they cite, and none of the cases have anything to do with the subject matter of an injunction sought by a government entity, whether it be Orlando or the state of Florida or someone else. They're all dealing with independent functions of a prosecutor doing a specific thing. One case involves a victim suing a prosecutor because they didn't do something pertinent to that. I mean, I go back to Judge Coleman, and I think Judge Coleman in the year 2000 or 2002 stated, I don't agree with this. In his flowery, colorful language, just shut that down. And the first thing that comes to my mind is when the question of damages came up, and there's a big, broad, bold issue in our brief, we are entitled to damages, we have a right to damages. Why wouldn't they come back and just unload anything and everything they have in their answer brief? They didn't do that because they strategically determined that they didn't hold water for a number of reasons, and now they're just banking on something that, I mean, there's not a case cited in their brief that remotely addresses what we're discussing. So
do you distinguish between prosecutorial immunity as it relates to individual assistant attorney generals or the entity in general? Do you make any distinction between those two?
Yes.
The acts of the agency versus the acts of an individual working for the agency?
Yes, because I don't think an individual prosecutor, whether it be Steve Mason or Louis Huebner or anyone else, I don't think they can come in and ask for an injunction and seek it. If they do that, they're acting as a private citizen. When they come in, they're acting on behalf of the state of Florida to enjoin specific conduct. And that's what occurred here. And I think whether it's a question of waiver or a question of public policy or a question of equity or however you want to frame it, the courts have decided a long time ago that we're not going to allow a government entity to come in and use us, our specific powers under Article 5, shut down these businesses, cause them great harm and injury, and then there'd be no redress. I mean, if you believed, if you subscribe to their philosophy that's in there, and that's what it is, it's philosophy rather than law, but if you subscribe to their philosophy, then that means the state would go in at any point in time and they could enjoin any conduct, whether it be something as extreme as bingo, and this is obviously an extreme case and you get extreme results from extreme things, and their argument is it's never compensable. And they use language that no matter how reprehensible our conduct is, this is close to a quote, no matter how reprehensible our conduct, it's beyond your reach.
Don't you think that if we were to agree with you, that would have a great chilling effect on the ability of government to try to do what's enforcement of the laws?
No, absolutely not. And this is why, I played...
Should the Attorney General's office be exposed to a $5 million or $10 million damages claim on every case in which they seek a temporary injunction in?
Well, I think the better question is to ask them, how often do you seek injunctions? How often has something like this really ever happened? This case was created from something that should never have been created. When I defended this case, I played bingo, as odd as it is, across the state of Florida, at least a half a dozen bingo halls. And when I walked out of there, I had a headache, and I realized that this was the most mundane, innocuous thing that I could not imagine. I would kid them repeatedly, why didn't any of you play bingo before you went in there and wrote this big injunction and took it to the judge at 10:30 in the morning and got him to sign it? It is an adult case. My goodness, in all their regular cases, they prosecute murderers and rapists and drug dealers and people that are unequivocally bad people. They're never going to be subjected to anything unless they take conduct that if it doesn't pass the smell test. This case...
But, that could be the law. Sovereign immunity is a general rule, and absent provident management, it could be true that the state could go in, shut somebody down, cause them millions of dollars worth of damages, and be completely immune. That's really a legal question that's being asked.
As a matter of law, I guess we could debate, I don't know if that's...
Under Wallace v. Dean, footnote 9, we're supposed to not consider vague notions of public policy, so...
Right, Wallace versus Dean, is not there. And I've got 6 minutes and 58 seconds left, and I'd like to reserve that for Mr. Egan, if I may.
Good morning, Your Honors. May it please the Court, Counsel. As you know, I represent the estate of Philip Furtney, but I have been counsel in this case since 1994, and that was 7 or 8 years before Mr. Mason joined up. I want to address some issues that he's not going to address and cover some matters that probably need covering. My brief is different than Mr. Mason's. I deal with some different issues. I just want to address a few of them so we could be clear, because when I got the reply brief back, I couldn't respond to it. There's a statement concerning prejudgment interest. In his reply brief, he states that I had argued in my answer brief that they never informed the court that they had any objection to prejudgment interest. They had filed a memorandum. The judge had sent out a copy of the final judgment, including prejudgment interest, and they filed a memorandum, and he included the calculations as to prejudgment interest. They did not object. And then I argued that in the thing, he was unaware of any objection they had. They didn't raise the issue. Then in their reply brief, they point out that the record shows that they filed 6 days before the judgment was entered an objection, a 2-page objection. And what I did is, that seems like a mistake on my part, but I went back and looked at the order, and the final judgment that was entered was actually entered on the 20th of August, and they filed their objection on the 20th of August. In the record where it refers to the filing of judgment. For some reason, they have the 26th of August. Mr. Huebner was not in the case then. I mean, that was handled by other counsel. But what Judge Johnson did, as you're aware, he was a Brevard County judge, senior judge. What he did, he signed the order, he faxed them to the parties, and then sent it over to the court. It didn't get recorded till the 26th, but the judge actually signed the order on page 10 on the 20th of August, and that's the day they filed their objection. Whether they filed it to it before or after they got a copy of his order, I don't know. But my argument remains, he never had a chance to see any objection that they made. The issue of prejudgment interest was never raised. When they saw the final judgment, they did not file an objection to it in any kind of timely manner. The other thing I want to address is this question of mitigation. I was the only counsel for the corporations. As you know, all business was done through the corporations, not through Mr. Furtney or Mr. Paget. The first hearing was held on November 21st, 1995. We had not been served yet, but I appeared at that hearing, actually spoke at that hearing, and that's in the record at volume 72. The other parties had filed a motion to dismiss the injunction and or modify it. I appeared and argued. I made the exact same argument we ended up making for the Florida Supreme Court, that you can't take bingo, turn it into lottery, and then turn a lottery into RICO. The judge, heard my argument. He ruled that he was going to rule. He ruled against the movements, but also informed me during the hearing that he was going to rule the same way when my motion came up. I, in fact, on the 21st, after I saw the complaint, on the 21st of November, filed a motion to dismiss and dissolve the injunction on those same grounds that we subsequently raised. And then subsequently, we had another hearing in front of the judge. And as this court may be aware, this injunction was kind of half-hearted. Judge Stroker entered it. It applied to something like 7 counties. But as the court might be aware, there was a judge down in Manatee County who got wind of it. One of our tenants, one of the corporate tenants, went to that judge, filed a complaint to dissolve the injunction, Judge Stroker's injunction. And the judge in Manatee County basically ruled that Judge Stroker's injunction would not apply in those counties. And on the same grounds that the Florida Supreme Court ruled. And when I went in front of Judge Stroker, I actually read him the ruling by this judge. And the judge says something like, "Who is this James Stroker that he thinks he can come to Manatee County and tell us what the law is? You can't turn bingo into racketeering." And I read it to Judge Stroker, and he's, and during the hearing he said, "No, I don't care." That's where they got this thing about he's ready to modify. He didn't modify anything. I mean, he didn't modify anything. This was brought in front of him. He was aware of it, and I don't want to say this in the wrong way, but if you read the lottery statute, it says right in it, this statute will not apply to bingo. It says clear as a bell. I saw it, everybody else saw it, and the Supreme Court saw it almost right away. How can you turn a misdemeanor bingo into racketeering? And as the court said, are you going to end up taking away people's churches? Is this where bingo? Because some guy doesn't have a sticker on or doesn't put the name of the thing. That's how it happened. And I think after a while, I did file a motion to get a receiver. We participated in everything. We did everything we could to affect this. We were able to keep 3 or 4 halls still operating. We were able to preserve the Bradenton hall. That's why this case is about 5 halls, not 13. The remaining halls were either taken care of or like the Kissimmee and Orange County Hall, they'd already been closed for over a year. I think Judge Johnson ruled on this question of mitigation. Mr. Huebner didn't participate in those proceedings, but the transcript of proceedings at volume 72, Judge Stroker's ruling about his refusal to modify this thing was crystal clear. Let me address the policy thing.
Hey, your time's getting short.
All right. And go over this. we all understand what Providence is about, and we all understand what temporary injunctions are and how dangerous they are, especially if you're dealing with an ongoing business. If someone's leasing property and you enjoin them, freeze their assets, they can't pay lease payments, and if the landlord gets notice that they're out of business, he's going to lock the door. Well, in this case, the state of Florida locked the door. We've had this issue about sovereign immunity a long time ago, and it's been a continuing issue because what the state of Florida can do through its police powers is ending up closing people out of business, taking property, doing all kinds of things. And what the state always ends up arguing, like they do in Providence, that this is a tort. And years ago, if this court remembers, we had that citrus canker issue. And back in the Department of Agriculture versus Polk, which was a Supreme Court decision in 1990, the court addressed this question. The Department of Agriculture went in there, took 500,000 citrus trees and destroyed them. And the state of Florida argued, well, this is a tort. They're only limited to 200,000. And the court said then, just like it said in Providence, if the state of Florida is going to go into someone's property, deal with someone's business, and destroy it or destroy their property, they've taken this out of questions of tort and statute. That a fundamental issue here is a matter of a taking. It's a constitutional right that we have to be safe in our property. And if the state of Florida, through the prosecutor or through an attorney general, wants to go in and shut people down, lock doors away, get people fired, make people lose leases, they run that risk. And I think the court has made it clear. The Supreme Court of the United States, the Supreme Court of Florida has made it crystal clear over and over again, when you shut people out of business, you run that risk. They ran that risk.
Sure, your time's up.
All right, thank you, Your Honor.
And I gave the appellee an additional 2 minutes, so I'm giving each 22 minutes here.
I only have
You have 3 minutes left.
Thank you. I have just a couple of comments, Your Honor. First is to the Wallace versus Dean case. In footnote 14, it cites, it says sovereign immunity relates to subject matter jurisdiction. Parties may not confer subject matter jurisdiction by waiver, failure to object, or consent where none is given by law. Governmental immunity may be raised at any time. And it cites the crop
Is that before the entry of final judgment, or can you continue to do that after 2 or 3 appeals?
No, I think you can continue to do it because we raised it throughout the proceedings below. The trial court did not specifically rule on the defenses when they were asserted in response to the motion.
Wouldn't you concede that under Airvac and Giuliano you waived it if it can be waived? I understand your argument that it can't be waived.
No.
I really don't get how you can argue in good faith that it was not waived when you had a definitive ruling below and then did not raise that issue by cross-appeal.
Giuliano is a law of the case decision, and it says that the law of the case only applies to decisions that have...
Right, it said Airvac is a waiver. Airvac is not a law of the case. It's about waiver. I mean, that's what Giuliani said, as I read it.
Right. No, I mean, the law is that we can't waive it. That's what Wallace versus Dean says. It's what Crop says. Governmental immunity may be raised at any time. Parties may not confer subject matter jurisdiction by waiver, failure to object, or consent where none is given. So I think those are still before the court. Another thing, as to the policy about the state having the authority to go in and shut someone down without a bond, I think that's exactly what 60.08 does. It gives the Attorney General and others seeking injunctions under Chapter 895.05, under 501, the Deceptive and Unfair Trade Practices Act, under Chapter 542, which is antitrust. The Attorney General goes in and seeks injunctions under these chapters frequently, and particularly in the last year, with respect to some of the mortgage problems, we have been in court a lot seeking injunctions.
Let me ask you this. If the Attorney General goes in, seeks a temporary injunction, there's no notice, no opportunity to be heard, a temporary injunction is issued and someone's business is closed down, and it turns out later that's wrongful, what do you suggest the remedy is, if any, for the wrongfully enjoined party?
The remedy is to get the legislature to address that in Chapter 895, or to modify Section 60.0.
Well, given the current status of the statute, is it your position that there is no remedy in that scenario?
There is no remedy in that scenario. No, there isn't.
All right, thank you. And your time is up. Court will be in recess.